This is the session, Michigan ADR case law update. Hear the latest from Lee Hornberger. What you're about to hear and the materials that you have in your registration materials are materials that you should keep on your proverbial and or virtual shelf. This is the update that we wait for every year. So Lee is going to present for us. Lee is just about Mr. Everything in mediation and arbitration. Best lawyer, super lawyer, former chair of the section, a winner of the Bashara Award, winner of the Hero Award. And without further ado, I'm going to say, take it away, Lee.
Thank you, Mike. I appreciate that. What we're going to do this afternoon is review Michigan cases over the past year regarding arbitration and mediation. First of all, whether you printed the whole 50 pages or not, lay the handout stuff aside. Please don't have that in front of you. Please put in front of you a piece of paper and a writing utensil, and ultimately later you can go to what we talk about today. As I go to a case, I will tell you what page number it's on. So if the case excites you, you can go to that page number later. The pages numbers we'll be covering, and you might want to write this down, are pages 1, page 7, page 12-15, and pages 42-51. We're going to do three things. Number one, very briefly, I think with two cases, we're going to go down memory lane. Number two, we're then going to spend some time on the case law update for mediation appellate cases. And then number three, we're going to do an arbitration case law update. Going down memory lane, the first place I want to go to, because I think it's an important decision that all of us every once in a while should go back and read. And this is the famous, or some people would say, the infamous pressure to settle case on page 40 of the outline. This is Vitiglio versus Vitiglio. Vitiglio versus Vitiglio is where the Court of Appeals affirmed the Circuit Court enforcement of an audio recorded MSA, domestic relations, MSA mediated settlement agreement. This was property, there was no children, there was a log mediation. When it was over, one of the parties argued that they had a change of heart and the MSA should not be enforced. The Circuit Court enforced it, the Court of Appeals affirmed, and the Supreme Court denied leave to appeal. And the famous line in Vitiglio, which keeps rattling through history as we go along, is, quote, a certain amount of pressure to settle is fundamentally inherent in the mediation process. In addition, Vitiglio, the published decision, as do some other cases, give us language we can put into our MSAs to help try to create a bulletproof mediated settlement agreement. And again, on page 40 of the outline, there's some language that was used in Vitiglio. The mediator questioned the plaintiff about her understanding of the terms of the settlement agreement. The plaintiff affirmatively indicated that she understood the terms, she had no questions for her attorney or the mediator, and she agreed that all of the terms were a full and final binding settlement of the case. Let's segue from Vitiglio and go to the second decision down memory lane. And this is the decision of Reddick versus Reddick, a published decision on page 41 of the outline. Prior to Reddick, whenever we had this presentation in October, I would say during the past year, there were 10 cases involving MSAs. And in half of them, the Court of Appeals refused to enforce an MSA. And those MSAs were in child custody cases where there was a change of heart by a parent after an MSA. They went in front of the judge to do the judgment of divorce. And one parent said, "Hey, I've changed my mind, Your Honor. I want a hearing on the best interest factors. I want a hearing on the established custodial environment. Please don't enforce the MSA." And invariably, if the trial court didn't do that, the Court of Appeals would reverse it. Riddick versus Riddick on page 41 of the outline brought that to a halt. In Riddick versus Riddick, we had a custody parenting time MSA. One parent had a change of heart, and the circuit court said, "I don't have to have a full hearing. I have deference. I can decide not to enforce the MSA, but based on the MSA and based on the fact that you folks signed it, I'm going to put the MSA into the JOD. And in addition, I don't have to determine whether or not there's an established custodial environment." That was appealed to the Court of Appeals. And the Court of Appeals affirmed the circuit court and said that the circuit court, if it recognizes it has discretion, can exercise that discretion to enforce the MSA and does not have to make an ECE finding. In addition, the Riddick decision on page 41 has a couple sentences that might go into a bulletproof MSA. Quote, "This memorandum of understanding spells out the agreement we have reached in mediation. This resolves all the dispute between the parties, and the parties agree to be bound by this agreement." Now what we're going to do is segue from history lane back to now. And we're going to work backwards from now, going backwards with some non-published Court of Appeals decisions involving mediations and or Court of Appeals decisions with MSA. The first one is the Teach Out versus Teach Out case, leave appeal pending on page 42 of the outline. And this scenario pops up a couple times in our review this afternoon. In the Teach Out case, the defendant husband managed to be found in contempt of court for violating 3 orders. Number 1, an order concerning paying spousal support. Number 2, an order concerning appraisals of property, and for our purposes, an order scheduling the case for mediation. So he disobeyed 3 sets of orders, and one of them was refusing to comply with an order for mediation. The circuit court found him in contempt and issued sanctions. The Court of Appeals affirmed. One of the reasons for the sanctions was that the defendant unilaterally canceled a mediation. We have to be careful, though, that this was a facilitative mediation, not an evaluative mediation under MCR 3.216. The next case we're going to review is Smith versus Forrest. Smith versus Forrest is a law firm partnership case. These people were partners in a law firm. The law firm broke down. There was no lawsuit. They sat down and they agreed on a settlement agreement. It could have been an MSA, but they agreed on a settlement agreement to do what you do when you have a law firm partnership case being broken up. Ultimately, they had an argument over their settlement agreement. And one of them went to court. This is the first time they've gone to court to enforce the settlement agreement. And they get in front of the judge, and the judge says, "Hey, I got a surprise for you. MCR 2.612 which involves enforcing orders and other proceedings, is applicable to this. Under 2.612, you all waited too long, and I can't hear this case. So there's an appeal, and it goes to the Court of Appeals, and the Court of Appeals reversed the circuit court. The Court of Appeals said, hey, 2.612 only applies to a court order or a court proceeding. It does not apply, the rules in it and the time periods in it do not apply bringing an outside non-court settlement agreement. Tyler versus Findling is on page 42 of the outline. This is a defamation case. We have a defamation case, and the defendant, the person who made the alleged naughty statement, says, you can't use those statements against me. When I allegedly made those alleged defamatory statements, I was sitting in a party room outside a mediation session, and I was there as a receiver for a party, and my statements that you say were defamatory were made as part of the mediation, and therefore they're confidential, and therefore they never happened. And the circuit court judge said that he or she agreed, dismissed the case, and said, in effect, those statements were never made. The Court of Appeals reversed. The Court of Appeals said that when the defendant in the ultimate defamation case came to the mediation place and sat in a room designated for the plaintiff, but was not a party, this did not make him a party and did not make his presence in that room part of the mediation process. There's a case similar to this on page 47 of the outline, Hanley versus Seymour, where defamatory statements were made allegedly during the mediation process. In Lang versus Lang on page 42 of the outline, we have another case involving a party not obeying mediation laws. Basically, in this case, in Lang versus Lang, he refused to obey orders regarding mediation and the sale of the marital home. The Court of Appeals held that the defendant attempted to find loopholes in circuit court orders rather than participating in good faith. And therefore, the Court of Appeals in Lang on page 42 affirmed the awarding of attorney fees. We need to be slightly careful with these cases because the mediation order that's being disobeyed, that is the predicate for the contempt rulings that are being affirmed, is not the only order being disobeyed, but one of several. Estate versus Brown is on page 43. This is from Grand Traverse County up here by Traverse City, and it's an absolutely wonderful case. This is a case where we usually don't look at the facts, but we have the decedent who's a father, and we have 3 children, the siblings who survive. And the decedent, before he dies, fills out a piece of paper saying where the money should go. The first page says, choice number 1, the 3 kids, even Stephen. Choice number 2, something else. Choice number 3, something else. If you don't choose number 1, fill out the second page. So he chose page number 1, filled out the second page, which meant there were inconsistent answers, which created nothing but litigation after his death. So we're in probate court, and we have lurking in the background one of the three siblings, which is Barbara, appellant Barbara. Early in the litigation, the court system, maybe the probate judge, sent a letter to everyone, including Barbara, saying, here's the scheduling order, and Joe Smith will be the mediator, and the mediation has to be finished by X date. The mediation has to be finished by X date. Then they go on and they have mediation. One of the other siblings is the executor. They have the mediation. Barbara allegedly does not know about the mediation date. Barbara isn't at the mediation, but there's a comprehensive mediation settlement agreement that really does a decent split of all the money involved. Barbara now surfaces and says, I wasn't there, I wasn't a party, and I never signed the MSA. And the circuit court, the probate court, disagreed. The probate court said the court system told you what was happening with the mediation, and everything was done hunky-dory. The Court of Appeals reversed the circuit court. The Court of Appeals said under MCR 5.120 that the executor, one of the siblings, should have kept her completely informed, and whether she was informed or not, you can't have a settlement agreement that binds her without her signature. And there wasn't such a settlement agreement, and therefore this did not bind her. Our next case, and these are unpublished cases, is the Brooks versus Brooks case on page 43 of the outline. This is an interesting case. We're in a courthouse and we're in the jury room. The jury room is next to the judge's courtroom. And in the jury room, we have the parties, the attorneys, and we have the mediator. And they come up with an MSA there's the mediator's notes, but is not quite signed yet. So based on the practice of this court with this kind of case, they go find the judge and they say, hey, judge, we have a settlement agreement. Can we get the court reporter or your recording system going, and we'll put it on the record. And then what they do is they read the agreement on the record in front of the judge in the open courtroom. Everyone agrees it's copacetic. And then I think the wife has what we call a change of heart. And she says, we never signed the MSA. There's no signed MSA. And the Court of Appeals said, no, you don't have to have a signed MSA when you bring the whole MSA in front of the judge in the courtroom under MCR 2.507G. You then basically have a court order that's been read into the record. On page 44 of the outline, leave appeal pending. We're going to go back and look at Pullman versus Pullman a little bit more, if you don't mind, just for a couple of minutes, please. We have lurking in the background MCL 600.1035. A little bit further back, we have MCR 3.216 paren H close paren 2 close paren. That's all at page 44 of the outline. 600.1035 says that when you're doing a domestic relations mediation, you're the mediator, SHALL, you shall do the domestic violence protocol. And that law was passed. The family law section pushed it as a good little law. There were big articles in the Family Law Journal, big articles in the ADR Journal, all kinds of CLE was done. So now we have Pullman versus Pullman. There's a mediation done. There's no domestic violence protocol for the purpose of what we're talking about right now. So then afterwards, everything gets goofed up. Maybe it was a good mediation, maybe it was a bad mediation, but there was no domestic violence protocol. None of this really was clear in front of the judge when the judge made the oral decision to enforce the MSA from the Pullman mediation. Then you have the 7-day rule for submitting an order. In response to the 7-day order, the wife then for the first time submitted all of her documentation showing all the alleged bad things that happened concerning this mediation. The circuit court said, too late, I don't have to consider those documents and enforce the MSA. It goes to the Court of Appeals, and the Court of Appeals in a 2-to-1 split decision says what was submitted during or after the 7-day order submitting process, we don't have to consider. It was submitted too late. I kind of look at Pullman versus Pullman from a bigger picture than getting too bogged down in what the alleged belated information is, which is, what does the state legislature have to say shall? I mean, is the Court of Appeals really saying if you have to say it twice or something? So right now there's an application for leave pending in Pullman. We do have the problem with basic information going in slightly too late. On page 44, we have Pearson versus Morley, Inc. This is a sexual harassment case where the plaintiff is suing an employer for sexual harassment. Somehow something happens and the plaintiff misses all kinds of discovery orders, all kinds of scheduling orders, and the circuit court ultimately dismisses the whole case with prejudice, and the reasons for it, include counsel's failure to adequately prepare for facilitation, end quote. So Pearson on page 44 is another case we're seeing this afternoon where people are being sanctioned. In the Pearson case, sanctioned with prejudice dismissal, in part for not complying with mediation ADR rules. Now, the next case is kind of like the probate case, the Brown case. This is Dolan versus Capuri on page 43. Page 43. Dolan versus Capuri involves two people who are tenants by the entirety. They own some property, tenants by the entirety. One of the two tenants sues someone to resolve some boundary lines or something with the property. The other tenant by the entirety is not a party to that lawsuit. And we're going to call that person N. N is not a party to the lawsuit. There's a mediation. N is not at the mediation and doesn't sign the mediated settlement agreement. The mediated settlement agreement purports to resolve the boundary line issue. And this goes in front of the circuit court, and the circuit court basically says that that person D knew what was going on, or she should have known what was going on. I'm going to make her a party, and I'm going to order her to comply with the MSA. The Court of Appeals reversed the circuit court. The Court of Appeals held the circuit court violated N's right, the tenant by the entirety, her due process rights, when it added her to the MSA without her consent, and the settlement agreement was invalid from the outset. Going back just a little bit, Corrales versus Dunn on page 45 of the outline. In Corrales versus Dunn, there's case evaluation. After case evaluation, the circuit court orders mediation of this no-fault case at the Dispute Resolution Center. There's a communication glitch. The plaintiff's attorney's secretary the plaintiff fails to appear at the mediation, and the argument is there was a goof up by the secretary, one of the historic goofs up by a historic secretary. The circuit court dismissed the case. The Court of Appeals reversed the dismissal. The Court of Appeals held that after 2 years of litigation, under the circumstances of this case, that dismissal was manifest injustice, citing MCR 2.410, all at page 45 of the outline. The lesson from Corollas versus Dunn is that counsel personally, not the secretary, the counsel personally should prepare the client for the mediation and make sure the client knows the time and place of the mediation. On page 45 of the outline is Eubanks versus Hendricks. This involved a case where there was an MSA, and they came up with an agreement during the MSA, but it wasn't signed. The next day, they're in a hearing in front of the judge. We have this MSA sitting there, but it's not signed. The circuit court says to the people on the record, it's my understanding that even though someone's objecting to the MSA, that you all agreed to continue with the joint physical and legal custody in equal parenting time. Both the husband and the wife agreed to that sentence or two on the record. The circuit court, being up with it, immediately found that that arrangement was in the best interest of the child and said that that part of the MSA, since they both agreed to it on the record, was binding. And the Court of Appeals agreed, so you ended up with a partial binding settlement agreement. So what we've just done is we've done a mediation review. We've seen Pullman on page 43 with the DV protocol. We've discussed absent people and due process with the estate of Brown, page 43, Dolan, page 43. We've seen the significance of court orders to mediate with Teachout on 42, Lang on 42, Pearson on 44, Corellis on 45, and we've seen change of heart with Brooks on 43, Pullman on 43, and Eubanks on 45. What we're doing now is we're segueing to arbitration cases. And the first arbitration case we're going to deal with is on page 1 of the outline. This is the famous Leishon versus Morse case, a published Court of Appeals decision, leave granted, and the oral argument in front of the Supreme Court was 2 or 3 days ago. Leishon, these are really twin cases, but I'll discuss it as one. Leishon was an employee of the Morse law firm. She's suing both the Morse law firm and Morse as an individual. Leishon is alleging there was some awful hanky-panky that she's eventually calling alleged sexual assault. And in the circuit court, the law firm says, hey, we have an agreement to arbitrate. It's a fairly broad agreement to arbitrate. This should not be in circuit court. It should go to arbitration. And the circuit court agrees, dismisses the lawsuit, and says, go to arbitration. There's then an appeal to the Court of Appeals. The Court of Appeals, in a split decision, reverses the circuit court and says this does not have to go to arbitration, it can go to court. The Court of Appeals majority decision said 2 things. Number one, it went into the minutia of the employee handbook language and said what she was suing for was not related to her employment, and to be under the arbitration clause, it had to be related to the employment. Then the Court of Appeals, in what was to be a published Court of Appeals decision, went a step further. And it said, quote, central to our conclusion is the strong public policy that no individual should be forced to arbitrate his or her claims of a sexual assault, end quote. Central to our conclusion, strong public policy. Judge O'Brien on the Court of Appeals dissented. And Judge O'Brien kind of said, well, gosh, I hope you were right, but that's not the established law of the state of Michigan. And yes, they do go to arbitration. Way looking back in the background on page 23 is Shea versus City of Hamtramck, a non-published case. Shea was vaguely similar. In Shea, we had an employee, there was some activity like the Leishawn Morse alleged activity, and she sued the City of Hamtramck. City of Hamtramck had an arbitration agreement. In Shea, the Court of Appeals ruled that the language of the arbitration agreement was not broad enough or good enough to compel arbitration of what was involved, and therefore there would be no arbitration. So why is Shea hidden in the dust of the background, and Leishawn versus Morse becomes Marbury versus Madison? Number one, Shea was an unpublished decision. Leishawn might have laid lower if it stayed non-published. Number two, Shea did not stick its neck out and say central to our conclusion, strong public policy, blah, blah, blah. Now, listening to the oral argument in the Leishawn case a couple days ago, there's a possibility this whole thing will end with a whimper. We don't know which way the 4-3 vote will go, but it may end up that no one's going to discuss strong public policy. It may simply be a discussion of the minutia of the wording of the Morse law firm employment agreement. Tinsley versus Yadamo. I don't know the numbers yet. It's on page 7 of the outline. For our purposes, is an important published decision. It's a legal malpractice case. Tinsley has legal malpractice. He has an attorney. Then he sues malpractice against his malpractice attorney. So Yodamar is his second attorney. Yodamar is the defendant. So Tinsley's now suing Yodamar, Yodamar being an attorney being sued for legal malpractice. Yodamar says, hey, you can't sue me for legal malpractice because in our fee agreement, remember, our fee agreement says that you agree we will go to arbitration if there's a legal malpractice case, and you can't sue me. The client says, no, that doesn't count because the Michigan Rules of Professional Conduct 1.8H, all at page 7 of the outline, says that the lawyer should not make an agreement prospectively limiting the lawyer's liability to the client for malpractice unless permitted by the law and the client is independently represented in making the agreement. The client is independently represented in making the agreement. And so the client person in the case we're talking about is saying, I never really had an independent attorney. You never told me to take this arbitration clause to an independent attorney. Therefore, this arbitration clause doesn't apply. And the defendant lawyer then says, yes, but you did go to Attorney Jones, didn't you? And he reviewed it for you. Attorney Jones then files an affidavit saying, yeah, I looked at it. He asked me to look at it, but you never told me to read the arbitration clause in the fee agreement, so I didn't think it was important. So what the Court of Appeals does in this case is it enforces the arbitration agreement. Based on the ambivalence in the decision, it could have gone either way. And the Court of Appeals decision says, we suggest contemplation by the state bar and the Supreme Court of amending the professional conduct rules to specifically address this arbitration issue. We're going to gradually mosey along here some more. And we're now coming to a really exciting case. This is on page 12 of the outline. This is Michael Moore versus Glenn. We keep coming back to Traverse City today. Michael Moore versus Glenn, who is Mrs. Moore, or the former Mrs. Moore. Michael Moore and Mrs. Moore co-owned and co-ran Michael Moore's basic business endeavors for 20 or 30 years. And now they're getting a divorce. They have to split all this up. There's the residuals going decades into the future. They have a major mediation and they come up with an MSA splitting these business properties. They're still tied together with the residuals, but they split the business properties. And there's a sentence in the MSA that says, if we can't agree on what the MSA says, we will have binding arbitration. Now, it helps now that we can go to the Supreme Court website and listen to the oral arguments. So there's a layer of knowledge here that's not in the decision, but it comes with the oral arguments. So we're now in an arbitration, according to the oral argument stuff. And Michael Moore says, I want an arbitrator in New York City. Now, this is a Michigan case, but he wants the arbitration in New York City. He'll want the arbitration in New York City. Then he says, I want this particular judge. She knows what to do in New York. I want her to be the arbitrator. So they get his judge, or his recommendation to be the arbitrator. They then have an arbitration. It goes on. And all of a sudden, Michael Moore's lawyer says, I don't like the way this arbitration is going. We're going to go back to Bel Air, Michigan, and ask the judge to stop this arbitration. So they all fly back to Bel Air, Michigan, and the judge says, well, I don't know when I can see you. Wait out there in the street. Judge, finally, 3 days later, they sit there 3 days later, all these New York lawyers, and they come in, and the judge says, continue with the arbitration. They continue with the arbitration, and then the judge makes a decision that Michael Moore venomously disagrees with. His locale, his arbitrator, but he still disagrees with the decision. That comes back to the Bel Air Antrim County judge, who immediately vacates the decision. That goes to the Court of Appeals, and in the Court of Appeals reverses the vacation and confirms the award, saying the judge did not have the authority to vacate the award. Let's go to a condominium case. This is on page 12 of the outline. Copperfield Village Association versus Tour. We have a condominium bylaws. And in the bylaws, there's an arbitration provision, and somebody wants to do arbitration. Now, normally when we all do arbitration and there's an arbitration provision and someone demands arbitration, it doesn't matter if the other party to the contract wants out. The thing that came up in the Copperfield Village case is MCL 559.154 on page 12 says that to have a condo arbitration, the arbitration must be, quote, at the election and written consent of the parties, end quote. That's the MCL statute. So the Court of Appeals held that both sides of the issue have to agree to the arbitration. On page 12 of the outline is the unpublished Interbelli versus Hartman case. Way back in history, on the bottom of page 2 of the outline is a prior Interbelli versus Hartman case. In the prior case on page 2 is a Supreme Court decision. Interbelli was a partner with a big law firm. Hartman is a senior partner with that law firm. Interbelli wanted to go to Alabama or someplace to become some kind of a football coach, but he still wanted to be part of the law firm. So says, no, you're gone, you quit. That's the argument. Did he quit, or have they fired him, or what? There was an arbitration clause. Interbelli tries to sue the individual partners to bypass the arbitration clause. In the Supreme Court antebellum decision on page 2, the Michigan Supreme Court ruled that the arbitration clause was broad enough to make antebellum go through the arbitration clause, even though he was not suing the corporate law firm. The antebellum case on page 12 is the same parties, but it's the result of the arbitration. Antebellum lost the arbitration case he didn't want. That's probably why he didn't want the arbitration. The arbitrator ruled that he voluntarily withdrew from membership with the defendant firm and had not proved his damages. Mr. Antebellum is not giving up the ghost. He took this to the Court of Appeals, and the Court of Appeals ruled on page 12 that this was a call for the arbitrator to make and affirmed the confirmation of the arbitrator's award. And by the way, this is now appeal leave pending. Appeal leave pending. Page 13, in a way, is a complicated case. This is Andrus versus Dunn. This is the Hurricane St. Martin case. We have a divorce. We have a condo on St. Martin. The decision doesn't tell us if it's the French St. Martin or the Dutch St. Martin, but there's a condo on St. Martin that the parties own. There's a divorce. The JOD says the husband will pay the plaintiff $1.3 million, but doesn't quite say when. In a different paragraph, it says the husband will sell the condo. Then there's a hurricane, and there's hardly any condo left. There's nothing left to sell, and the $1.3 million isn't paid. In the JOD, it says if there's an issue concerning the condo and the $1.3 million, it will go to arbitration. The parties are trying to resolve the situation, and they negotiate a new agreement. Then they negotiate a new agreement. Then ultimately, one party says, we want to arbitrate this condo issue. And the other party says, no, that sentence is no longer on the most recent version of our most recent agreement. And the circuit court agreed with that, and the Court of Appeals agreed. So the lesson from the Hurricane St. Martin case on page 13 is if you have an arbitration agreement in a document that you like, be careful as you renegotiate that document and come up with new documents. You don't drop that sentence and lose the arbitration clause that you would like. Shannon versus Ralston is on page 13. In this case, the Court of Appeals affirmed the confirmation of a 39-page Domestic Relations Arbitration Act award that changed and involved the primary custody of a minor child in a bitterly fought domestic relations case. The Domestic Relations Act says that the arbitration award has to be issued in something like 30 days. This arbitrator issued his, I think, roughly a year, not 30 days. But everyone's sitting there nice and polite, waiting for the award to come. The award comes, the wife loses, she goes to court and says, hey, 30 days was violated, vacate the award. And the Court of Appeals says, no, the reason it was delayed is because the arbitrator was asking you people for financial information and proposed findings of fact and conclusions of law, and it took you all a year to get those to the arbitrator. So if you're a party that's going to argue delay, don't cause the delay. On page 13 of the outline is Century Plastics versus Fremo Inc. Fremo Inc. Century Plastics is a small, decent Michigan corporation trying to operate a business. They need a certain product, and they go to some Fremo company to order the product, and it's ordered. Eventually, as before the product comes, they get a price quote from the Fremo people that says you have to go look at our general terms. They go look at the general terms and they say this offer is based on the general terms, which can be seen on our website at blah, blah, blah. Well, who knows if they looked at the website or not. But if they had looked at the website, they, number one, would have discovered there was a mandatory arbitration clause. And number two, they would have discovered that the arbitration had to be in Germany. So eventually, when there was an argument over the product, they maybe looked at the arbitration clause more carefully and said, having to go look at this website for a Fremo company that's not even named in the basic literature is not right. The Circuit Court and the Court of Appeals disagreed. And the lesson from Century Plastics is be careful when you do business with people that say, go look at our website. You're bound by what's in the website. Let's do Dowd versus Dowd on page 14. In a vague sort of way, Dowd versus Dowd is like Pullman. That's not fair to Dowd, but in a vague sort of way it is. Dowd versus Dowd involves the Court of Appeals affirming the confirmation of a Domestic Relations Arbitration Act award. The Domestic Relations Arbitration Act says that if you're going to have a domestic relations arbitration, and if there is a present PPO or if there is present domestic violence, the judge has to tell the parties in open court, these are your Miranda rights about mediation. That has to be done in open court, out loud from the judge. In this case, way back at the beginning of the process, the wife's attorney, the husband's attorney, both spouse people, the judge are all in the courtroom, and the attorneys say to the judge, Your Honor, we have a piece of paper signed by everybody. It's copacetic. We want to have an arbitration. Please sign it. It's a decent document. The judge signs it. Then they have the arbitration, and the wife loses the arbitration. The wife's lawyer then goes back to the judge and says, Hey, Your Honor, we forgot to tell you something. There was domestic violence in PPO, and therefore, even though we asked you to sign the stipulated signed by client lawyer arbitration agreement order, you couldn't sign it because you never read the Miranda rights out loud. The circuit court said, You've got to be kidding, and enforced the award. That went to the Court of Appeals. And the Court of Appeals, in oral argument, even basically said, You've got to be kidding. In the Dowd written decision, though, they point out that the PPO was a prior PPO that had been vacated for insufficient evidence, and that the domestic violence was past domestic violence, and they interpreted the DRAA statute not to cover past. Say again?
Sorry. Oh, my audio. I'm messing. Can you help me with this really quickly, Tom?
How much time do I have?
You got it?
You have about 7-8 minutes, something like that.
Okay, fair enough. On page 14, in Lesniak versus Arkine Builders, the Court of Appeals reverses a denial of a motion to compel arbitration. This was where the party that didn't want arbitration said the arbitration clause did not cover the issue. And the Court of Appeals said that any doubts about arbitrability should be resolved in favor of arbitration. It's a broad wording. Quote, construction and purchase agreements establish the party's intent to arbitrate because they are temporally and substantive integral to one another such that they must be construed together. On page 14 of the outline is a fun case. It's domestic uniform rental versus Rivers Bend rehabilitation. In the Michigan Uniform Act, Arbitration Act, and the Federal Arbitration Act, there are some limited ways for a court to vacate an arbitration award. One of those reasons is if the arbitrator refuses to adjourn an arbitration hearing without just cause, without a good reason. In domestic uniform rental, there were three parties. There was a bunch of individual people grouped together as a party with their lawyer. There was a corporate entity with their lawyer, and there was a second corporate entity with their lawyer. Several days before the scheduled arbitration, the arbitrator asked all the parties to submit a status call document to him, telling him if they had any problems, anything they wanted him to do, what should he know. One party, maybe by whatever, did not submit that document, That becomes slightly important later. We now get to the morning of the arbitration. Everybody is there. But the group of combined individual people say, we've resolved our differences. We're making a motion to let us go home. We want to go home. We've settled. We're out of here. There's some oral argument, and the arbitrator ruled, yes, if you've settled, you had a claim against somebody, you've made your peace with them, you're out of here. At that point, the appellant says, well, if they can go home, we can go home. And the arbitrator says, well, why are you going home? You haven't settled. Well, yeah, but we have to readjust our case because a third of the people aren't here anymore. And the judge says, well, that's the way it is. I'm going to go ahead with the arbitration. You're here. The remaining other corporate parties here, we're going to do the arbitration. Well, the ultimate appellate party then goes home. They go home, they leave. And the arbitrator goes ahead with the arbitration with the one remaining party, enters an award, and the party that left loses. So we're now in the Court of Appeals. And again, oral argument here is interesting because there's no love lost between the attorney for the departing party and the person who was the arbitrator. So one lesson from domestic uniform rental is if you're representing a party in the Court of Appeals doing an oral argument, you might be better off, do not mention the arbitrator's name in oral argument unless it is to honor the arbitrator, because it doesn't come across nice when the purpose is to dishonor the arbitrator. But the Court of Appeals ruled that, number one, they could have stayed. There was no reason to grant the motion to adjourn, and they agreed with the circuit court that the award could be confirmed. In addition, during the oral argument, one of the Court of Appeal judges said to the attorney for the appellant, did you ever submit that pretrial status document the arbitrator asked for? No. Why not? It's just a piece of paper. Well, didn't it say shall? Yeah, but that's form over substance. It's only a piece of paper. So again, another lesson from domestic uniform, if you're an advocate, is if the arbitrator asks for a piece of paper involving something, maybe submit the piece of paper. On page 14 of the outline is MBK Constructors versus Lipican. Usually in arbitration, if there's an issue as to whether or not an issue is arbitrable, if it's a substantive arbitration issue, is the language broad enough, that issue is decided by the court. It's a gateway issue decided by the court. The AAA rules, most if not all of them say, under our rules, those issues are decided by the arbitrator. In the MBK issue, the arbitration agreement said the rules of the AAA would be followed. and there was an issue of arbitrability. And the Court of Appeals said in the MBK case on page 14, you follow the AAA rule, which is that the arbitrator will decide these gateway arbitrable issues if that's what the AAA rules. There's a recent Sixth Circuit case, Piercing versus Domino's Pizza, number 19-2388, number 19-2388, that says the same thing. On page 15, there's what I think is a very interesting case. It's the 2727 Russell Street LLC versus Deering case. In this case, the Court of Appeals affirmed the circuit court's confirmation of award. They basically said the arbitrator's factual findings were not reviewable. What's interesting in this is during the losing party is saying the arbitrator never should have decided that these properties went to a non-party. The arbitrators ruled that these properties go to a non-party. And the Court of Appeals said, look, you all agreed that the issue was, are the 6 properties part of the settlement? And if so, who would get them? Are the 6 properties part of the settlement? And if so, who would get them? Question mark, end quote. So the Court of Appeals said that the wording of the issue gave to the arbitrator an almost non-reviewable ability to answer the issue and say where the 6 properties will go. So the question then is, what happens if you're the party who really believes, yeah, that's the issue, but we want to make it clear that no matter how the arbitrator rules on the issue, he or she's going to be so wrong, we think it should be vacated. So if you're not willing to live with how the issue is going to come against you, then be careful how you agree to word the issue.
Hey, Lee,
Yes, sir.
stupendous as always. You're out of time. Do you have some more you'd like to do?
Let me collect my thoughts. Let me take 30 seconds, okay?
Sure.
Do you mind? I don't want to goof everyone up. So basically in arbitration, what we have is the scope of the agreement is important. Lyshon, Andrus, Sentry, MBK. The attorney fee agreement, very important published decision, Tinsley. Court deference to the arbitrator, Michael Moore, Attabelli, Shannon, Dowd, Lesniak, Domestic, and 2727. The take-homes is even if the Court of Appeals disagrees, the domestic violence protocol is present. In addition, we always have to think, is everyone here who should be here? Is there someone hiding someplace who should be at this mediation table? And also protect ourselves from the people who change their hearts. Thank you, sir. That's it.
Thank you. Just so everybody knows, you can stay a little bit later in this room if you want to ask questions of Lee or talk about any particular issue. But if you want to go to another educational event, you've got to leave the room and go to the landing room. So Lee, outstanding as always.
Thanks, Mike. That's kind of you.
I just would point out you're going to have the opportunity to talk about Finling possibly again in the future. Application for leave was very recently filed.
Go ahead, Mike.
I was going to say, in Finling, application for leave was just very recently filed. So it's sitting in the, the Supreme Court at the moment.
If there's some questions, I'm here.
Yeah, I don't see any. All I see is numerous congratulations.
I'm gonna print that and frame it. I'll clue you.
I think that everybody, I think not only
Save chat.
have you answered all the questions,
I didn't
but,
see any. I could be wrong. I didn't see any.
well, wait a minute, I just got one. In the defamation case, does this mean that parties can reveal what non-parties say in mediation? I think that's a reference to the Findling case.
I think in the Finley case, which was the receiver, I think that's the receiver
Yeah,
case.
yes, it's,
The geography of where the statement was made, I think was extremely important. I think if they had brought the non-party receiver into an actually being used caucus room or into the middle of a real joint session, unless he was off on some completely irrelevant tangent, I think his statement might have been more protected.
I think that I want to comment on that just because the section is going to prepare an amicus brief in this case. There are about 3 issues that are going to be addressed one way or the other. One of them is the scope of confidentiality, the standing of Findling, who's the receiver, and when does the mediation process begin? I would say in answer to the question, in the defamation case, does this mean parties can reveal what non-parties say in mediation? Boy, I wouldn't personally, I would never go that far because that would destroy the confidentiality that covers
agree,
mediation.
no.
So as a
Again, I
general
think
statement, I would not agree that parties can reveal what non-parties say. And finally, because this is going to the Supreme Court, I would hold David Findling was a receiver, is a receiver, and he was in this mediation in his capacity as receiver. And there's a pretty good argument that he was the real party in interest for the plaintiff. And he was the only one who had the right to talk about and to participate in the mediation. There's a lot to say and unpack about that case. If you want to read something and have your eyes glaze over, read the Court of Appeals opinion. Another question. I would like to do training in mediation. How can I enroll in a session? Interesting question. There are a number, pipe in or jump in if you'd like. There are a number of training sessions available in the state. I know that Shell Stark and others offer those. I would Google Shell. I would Google Bob Wright. I would Google Ann Bockley Pfeiffer. I would look at who am I? I'm leaving out so many people.
I would go to some of the major community dispute resolution center directors.
Perfect answer. CDRCs, the Community Dispute Resolution Centers, and go to the ODR website listing, the ODR Online Dispute Resolution website listing trainings. Thank you, Ann. There's a wealth of information out there, frankly. I hope that's helpful.
Zena had a question.
No,
I'm
I'm the one who asked about arbitration.
Okay, thank you.
Thank you, Mr. Lee.
Thank you, ma'am.
Thank you, Mr. Michael or Michelle.
Thank you. Thanks for joining us.